Y en nombre de nuestra Junta Directiva de CRISTIC, les damos la más cordial bienvenida a nuestro desayuno conferencia de este mes, el mes de noviembre, el último del año. Tenemos el gusto y el privilegio de tener con nosotros a Aurélie Houet, quien es Special Counsel en Arbitraje Internacional en el CP área. También cuenta con una maestría de Derecho en la Universidad París I, Panteón Sorbonne. Asimismo tiene una extensa práctica, tanto en teoría como en la práctica, en arbitrajes nacionales e internacionales, regidos por el reglamento de la Corte Internacional de Arbitraje, de la Cámara de Comercio Internacional. Asimismo tiene también experiencia en arbitrajes regidos bajo el reglamento de la Magistral y arbitrajes obviamente en el tema de inversiones, llevados mediante el CIAI. También tenemos el gusto de comentarles que Aurélie recientemente se ha incorporado al equipo de CRECIC y forma parte de nuestra junta directiva, lo que nos enorgullece mucho. Y sin más preámbulo, le damos con eso.
Buenos días a todos, muchísimas gracias doctor por su presentación, muchísimas gracias a la CRECIC por la invitación a este desayuno. Es un honor para mí estar acá con ustedes y muchas gracias por su presencia hoy a este desayuno para platicar sobre el tema de la financiación por terceros del arbitraje internacional. Como me indica el título, es una presentación que yo voy a dar en inglés esta mañana, pero con mucho gusto cualquier pregunta en inglés o en español es bienvenida. So, the topics of the effects and challenges of the right of financial investment in international arbitration, I thought that would be an interesting topic to address this morning because it is an area that has developed a lot recently. So much that even you may have come across this institution in terms of third-party funding or dispute funding or international arbitration investment. I mean, it has developed so much; it has grown exponentially. So the very definition is actually itself subject to quite some discussions as well. And I thought it would be interesting as well because it has grown. There's a higher number of cases that are being funded. Higher capital available to fund cases, and also globally it has grown and it has developed in terms of the type of mechanisms that you can actually use when you want to fund a case, as we will be seeing this morning, and also for the cases that are public that we can see more so in the field of investment arbitration. We can see that many fundings have involved cases involving Latin American countries. So it is an area that is developing everywhere, and it does gives rise to some interesting questions with respect to the process itself. How do you secure the funding? And also very interesting questions with respect to the impact that third-party funding and the participation of a third party to an ongoing arbitration process has a lot of effect in terms of issues of conflict of interest, issues with respect to cost, and some very interesting evidentiary and ethical issues that also arise in this context. So I thought it would be interesting to talk about this morning. And also 2017 has been a pretty busy year globally in this area. So just a few words in introduction. When we talk about international arbitration investment, really what we're talking about is kind of international arbitration as a new darling of Wall Street, with arbitration-related investments which can offer uncorrelated returns. And that is what is interesting, is that basically returns in this field are not dependent on the state of financial markets, which make them very interesting. So just to the second point is a quote from basically a short description on the website of Burford Capital, which is a major funder on the market. How they describe their activity in those words, quote, "We look at legal receivables arising from pending claims, resolved claims, or law firm activity as financeable assets. we use the value of those receivables to craft financial solutions for single commercial matters, portfolio matters, or bespoke vehicles. I mean, just from this very brief description, we can see that the field of financial investment in international arbitration has become much more complex and is really a multifaceted institution that offers various mechanisms. And we will see the key of this area also is the very specific nature of the underlying investment, which is basically investing in the pursuit of an arbitration claim or in the enforcement of an arbitral award. And we will see that precisely it is this very specific nature of the underlying investment which is itself subject to its own rules, and the interplay that it has with all the rules and laws that apply to the actual arbitration process, to the actual process to enforce the award. So we'll see that this interplay between the two actually gives rise to these interesting questions at the time of securing the funding, and subsequently with respect to the ongoing process, the arbitration process itself, as I mentioned briefly, in terms of conflict of interest, cost, and evidentiary issues, as well as ethical duties for counsel. So very briefly, in a first part, I've kind of broken down this presentation this morning in two parts. The first part will be looking at some interesting questions when it comes to securing the funding, and then we'll look at some of the challenges on the arbitration process itself. As I said, we'll be looking at questions of conflict of interest between arbitrators and funders, questions of cost. We're looking at what kind of cost, does it have any impact on the cost you can get, on the question of allocation of cost between the parties, as well as issues of security for cost. And finally, I will touch upon a few very brief considerations with respect to the impact on counsel duties, ethical duties, and some issues of privilege in the context of the arbitration process. So, what is the international arbitration investment landscape looking like? I mean, it is a reality that has developed quite recently, I mean, past decades. And in the beginning, it was really, there was a lot of debates about whether or not we should allow to permit third parties that are not a priori, they have no connection with the matters, whether we should allow them to fund a case. So, but undeniably, it has happened, and third-party funding is part of the international legal landscape. So now, the debate is not so much on whether or not we should allow it, it has shifted to how do we regulate the issues that it definitely gives rise to. So, the definition, as I said, you must have come across in your readings or practice with different terms to refer to this reality. Let's talk about the most basic application, non-recourse third-party funding. What is it? Well, it basically involves a third party that is unrelated to a dispute, but which agrees to fund a party's cost to pursue a legal claim in expectation of a financial return in case of a successful outcome. So that's non-recourse. If you don't win the case, the investor loses its investment. There's no payment. So we'll see that some key aspects, of course, the scope of the funding, when it comes to the claimant is negotiating the funding with the funder, of course we'll be looking at what will the funder pay. So the scope of the funding, which is in practice referred to as the outlay, is going to be important, and most of the time it will cover the legal fees of the attorneys, the arbitration costs to pursue the claim, and other important areas will be to see if the funder would agree to cover potential liability for an adverse award of cost should the funded party be unsuccessful in the claim, and other potential responsibility to post security for cost should it be awarded or ordered by an arbitral tribunal. The financial return also will be an important point of negotiation between the claimant and the funder. How much will the funder get if the case is successful? What will the fee be? Very often it is a combination of course, getting the funding back and getting a percentage of the proceeds. So initially, non-recourse funding developed in relation to litigation cases and not arbitration in common law countries to truly give impecunious parties access to justice. Actually, it developed regionally in the 80s in Australia to help companies that were in bankruptcy to start some cases that would help them to recover money that is owed to them. Nowadays, it has expanded from litigation, it has expanded to arbitration, international arbitration, initially to investment arbitration and then to commercial arbitration, and it has been expanding globally as well. As I was saying, 2017 has been pretty busy in terms of different seats. Singapore, Hong Kong, in Asia have been very proactive in revising their legislation in order to offer some clearer perspective on where do we stand in these countries with respect to third-party funding, because we truly are in a situation in international arbitration, the battle of the seats, where every city is trying to be the most attractive with respect to third-party funding, with respect to arbitration and third-party funding being part of the landscape. It's important to give parties clarity as to what is the rule, what are the rules. And as I was mentioning, third-party funding has evolved. We're not anymore just talking about a case-per-case funding, non-recourse funding, but it has evolved into more complex and innovative legal cost and risk management mechanism. From case-per-case funding, we're now talking about portfolio fundings. Funders are interested to look at portfolio cases. Also, parties are using proceeds that they might have in arbitration as a collateral to raise capital for other purposes, for operating expenses. We also have some models that consist in equity financing. So it really is a complex and sophisticated area that we are witnessing. So just briefly, just to look at some of the factors that can explain this expansion of third-party funding to international arbitration. Well, first, the high value of claims, especially in investor-state dispute settlement cases. If we look at the United Nations Conference on Trade and Development, they had recently in November their special update on investor-state dispute settlement facts and figures in November 2017. They looked at cases, ISDS cases from 1987 all the way up until now, July 2017, and the facts they have are the following. On average, successful claimants are awarded 40% of the amount claimed. In those cases that were rendered in favor of claimants, average amount claimed was $1.35 billion, and the median was $130 million, which is more useful of a figure because we have so much extremes in terms of amounts that can be claimed across the spectrum of all the cases. But it is a lot. And in the cases in favor of claimants, we see that the average amount awarded was about $500 million, and the median amount was $19 million. So that's one aspect. It's interesting for investors because there's a lot of money involved. The claims are high, and the prospective return can be high as well as a result. Of course, the finality of arbitral awards, as we know for an investor, it's interesting to know that, if I have a stake, some skin in the game, the underlying investment is the pursuit of a claim. It's better if there is some kind of finality. We don't have to go through all the stages, all the way up to appeal, cassation. Here we see that in international arbitration we have finality, no appeal most of the time, and challenges only on limited grounds, as we know. Also, the international enforceability of the foreign award. So what you're going to be getting at the end when you're pursuing as an investor, you're financing the pursuit of a claim, knowing that you're more likely to be able to enforce your assets internationally is also interesting. And another very important factor that has explained the development and expansion of third-party funding to the field of international arbitration has been the increase of cost. As we know, arbitration is expensive, and creates a need. So just looking a little bit more closer to this issue of cost, the not so glamorous reality of international arbitration, categories of cost. I mean, as we know, when we go into an arbitration, basically, we're going to be dealing with party cost and arbitration cost. Party cost, the attorney's fees, any cost that might be associated with, having expert witness, fact witness, executive costs as well, and this is in question as well, if these costs can be recovered in the context of an arbitration. I mean, you as a company, you're going to have your executive teams, you're going to have your in-house counsel dedicating time and efforts and energy to working on a case instead of working on their day-to-day business. These also have a cost. Arbitration costs, of course, the arbitrator's fees and reasonable expenses, and institutional fees in the context of administered arbitrations. I've used the numbers, average cost in investment arbitration. Again, the awards are public, so we can get more information and data on this. So average cost for claimant, about $5.6 million. Average cost for respondent, about $5 million. Average of tribunal cost, $882,000. So it is expensive. And if you look at the graph on the side, you see that 82% of these costs are party costs or attorney's fees, 16% arbitrators' fees and reasonable expenses, 2% for institutional fees. So it is expensive and very often actually a deterrent. Parties with a legitimate meritorious claim are prevented in practice to initiate it because they can't afford having to pay for the arbitration cost. So, who are the players in this market? Before, what we're looking at today, non-recourse third-party funding and these very sophisticated mechanisms, there were other ways to fund cases that have been existing for a long time. I mean, even us lawyers, when we participate and work on a case on a contingency fee basis, we are funding this case where our compensation is dependent on a successful outcome in that case. Of course, the funders. Funders themselves are various players. We have specialized litigation funders. We have hedge funds that invest in litigation funders. We have investment banks, which invest directly or indirectly in arbitration, as we've seen and as we will see through various mechanisms. I've put the name here of some of the major, the list is far from being exhaustive, some of the major players out there on the market. Insurance as well offer suites of products that are specifically tailored to arbitration to cover the insured's liability for legal fees and costs and potential liability for the opponent's fees and costs in the event that the insured is not successful in the arbitration. So we have what we've seen before the event insurance and after the event insurance. So we have different kind of players on the market. What are the funded cases? What are funders interested in when they look at whether or not they're going to be funding a case? Anecdotal evidence supports an average review to acceptance rate of 10 cases to 1. For every 10 cases that funders are going to be reviewing, just one will be the lucky one. So they are very, very stringent and very conservative as well in their approach. When they review a case, they are very conservative. So the main factors that funders will be considering in their due diligence process when they're going to be reviewing the case to determine whether or not they will be funding it, of course they are interested in cases with a significant financial claim involved, which can be part of a main claim or a counterclaim, which is why most of cases funded are actually they're funding claimants and not so much respondent, unless respondent has a significant counterclaim. Now, we're seeing another trend as well, where significant financial claim is not necessarily what is interesting for them. As we've seen, we have some good cause / not-for-profit funding, where you have funders that will be funding a claim to defend a cause, and that's what we've seen in the Philip Morris v. Uruguay case, exit case, where Philip Morris, all these claims were dismissed. In that case, it was the Bloomberg Foundation's campaign for tobacco-free kids that had actually helped Uruguay in the process. And so the idea is really to defend certain good causes. Other factor the expected budget for legal fees and costs. I mean, they're looking at how much it's going to cost in terms of legal fees, in terms of if we're going to be necessitating expert evidence, we're going to be looking at expert costs. So they really look at what would be the expected budget and the ratio of cost of budget to realistic value of the claim. They want a high probability of success, so they're going to be very carefully looking at the merits of the case, the legal merits of the case. What is the success of the case depending on? I mean, are we heavily relying on the law? Are we will be relying on fact, evidence? So we look at that. What is the strength and what are the strengths and weaknesses of the case? Creditworthiness of the opponent. You want to make sure that if you do win the case, you're going to be able to get your money back. And when it involves states, you can actually have public information with respect to the state's payment record. Is the state complying with the awards or not? We look at whether we have a favorable enforcement framework. Again, if we fund the case and we win the case, if we know that the respondent is likely to not be complying voluntarily with the award, we need to know, should we need to enforce, where are the assets? Where are they located? Are they located in New York Convention states? Are they located in states or countries that do not allow third-party funding? Because we know that this might be an issue. If the assets are located in a country that does not allow third-party funding, you could have issues of the award being challenged on grounds of public policy under the New York Convention. So you really want to make this due diligence and really know and master every aspect of your case. What is the seat? What are the applicable rules? What legal team is in charge of managing the case? What will be their compensation structure? Will they have skin in the game as well? And also you want to know if your potential funded claimant has any prior financial obligations to other funders or creditors. So now, what kind of investment models is happening and do we have in practice? As I said, the most basic one, case-by-case, non-recourse claim funding. So you fund the cost to pursue the claim in exchange for an interest in a favorable outcome, whether it be an award or settlement or other kind of outcome. No payment is due if we lose the case, so the investor loses its investment. And it's interesting for companies because it's an off-balance sheet funding where it does not pressurize the budget and can allow the company to dedicate its money on its core business, on its operating expenses. Now we're seeing portfolio funding as well, where funders are funding a portfolio of cases that can be a deal with the law firm directly, where basically the claims may very well be from different clients, or it can also be portfolio funding to one company, to one corporate claim holder, and this is also interesting in that case for the corporate claim holder who might have the possibility through the portfolio funding to have specific cases funded that would not otherwise have been funded, defense cases, for instance, which do not necessarily have a claim made in this context. And of course, we see immediately that portfolio funding in both models involves some form of cross-collateralization of the risk, where the funder's return is dependent on the overall net performance of the portfolio as opposed to the outcome of each particular case. We also see arbitration award enforcement financing, so where the funding is about funding the enforcement process. This can be built into a funding agreement that also deals with funding the process. So you have to make sure as claimants, when you negotiate the deal with the funder, that you're going to be incorporating as well cost for going into the enforcement phase should it be necessary. Or it can be a funding for enforcement collection efforts only. Or it can even take the shape of claimants, the successful claimant, just selling the award at a discount rate to the funders, so in order to get immediate liquidity available. Also, we are seeing working capital financing where the legal assets are used to raise capital for other purposes, to fund, your operating expenses, your pre-existing liabilities. So here we really see that a claim that you might have, an award that you already have, are really used as an asset, as a financial asset to raise capital. And in this context of working capital financing, here again, the funder's return is secured by an interest in the claim, and which is tied itself to a successful outcome in the case. Equity financing, this can be very useful in practice as well, where what we're going to have is very often it takes the shape of creating a special purpose vehicle, an SPV, where the claim of this SPV is the legal asset itself, that these are the only asset. The funding is structured as an equity that the funder will purchase in the SPV, and the funder's return, therefore, because he has an equity interest in the SPV, the return takes the shape of profits generated from the success of the arbitration. This can actually, this way of doing it can be very interesting because it might help and may help avoiding issues of prohibition of third-party funding under the torts of maintenance and champerty. As we will see, it has been some obstacles in practice to the development of third-party funding, common law torts of maintenance and champerty, which basically prohibit the possibility of an unrelated third party to maintain the pursuit of a claim, or to maintain that's maintenance, or to maintain the pursuit of a claim in exchange for a financial return that's champerty. You can avoid these prohibitions when you structure it like this, because you're not a third party anymore. The funder is not a third party anymore. It has an equity interest. It's part of the company. So we don't have that problem, and that might also help avoiding privilege waiver issues in practice as well, because you are the company, you're not sharing privileged information with a third party anymore. So it helps also with respect to protecting privileged information and confidentiality. Some quick examples of funding in investment arbitration. I mean, the largest case ever funded was Crystalex versus Venezuela, an exit case. And in that situation, the funding actually enabled an insolvent Canadian mining company to pursue its claim of unlawful expropriation by Venezuela of the Las Cristinas gold mine. It was a debtor in possession financing structure. Crystalex won $1.38 billion award, and in the end it was about 70% of net arbitration award. So it was a very interesting investment. Another example that I mentioned earlier, which is more a not-for-profit funding example with Philip Morris versus Uruguay. Here again, the claimants, all its claims were dismissed, and in the context of the arbitration, claimant was ordered to reimburse part of respondents' cost in the amount of about $7 million. Another example, which is a pending exit case, is the Eco Oro Minerals Corp versus Colombia. Here we have a capital financing of about $14 million US for over 70% of gross proceeds, excuse me. And from public information that I've seen, I mean, we're looking at Eco Oro Minerals as involved at least $250 million of investment. So the claim is going to be more. So again, we see that the amounts claimed are high, and the prospect of return can be high as well. Now, moving on to the challenges that I was mentioning in introduction. So challenges with respect to the operation itself when it comes to securing funding, and we'll see later on the other types of challenges that we are faced with. So challenges regarding the investment operation itself, meaning the process of securing these third-party funding. Let's look at three elements: the due diligence phase, and then the importance to make sure that you're going to be concluding a lawful funding agreement and an effective one. So the due diligence phase, you have your client and you're looking for funding opportunities. You're going to be looking at the markets, making sure that the funder is financially stable. I mean, you're going to be doing as lawyers your due diligence to see what kind of funder are you going to be approaching, and they have a lot of information on their website with respect to the kind of cases they're interested in or not. So as lawyers, you're going to be doing your own due diligence with respect to the funder selection. But the due diligence that I'm referring to here, the due diligence that the funder is going to be doing at the stage of assessing whether or not he is going to be funding the case. So case assessment, as I said earlier, we're looking at the case merits, we're looking at the amount of the budget necessary, the claim value, minimum ratio between funding and realistic claim value of 1 to 10, so it's very conservative. We're looking at the legal landscape and enforcement landscape. So if the funder is satisfied with what it's looking at, usually in that phase, the funder will make claimants a conditional offer that will be contingent upon a more detailed due diligence that usually the funder will have done with its own external lawyers that he will hire to very carefully do a very detailed due diligence and case assessment of the particular case. You might have an exclusivity that might be requested. The funder might ask the claimant, you're going to give me exclusivity during this period. So this is something that it's negotiable. You might want to look at it carefully when it's being requested. And also in that very important phase of case assessment, as lawyer for your claimants, you make sure that you have non-disclosure, confidentiality agreements signed. So that's the due diligence phase. Once we know that we're going to be going forward and the funder is interested in funding the case, well, let's make sure that the contract, funding agreement itself, is going to be lawful. As we've seen, this is very important because if you go through the arbitration claim process and you win, if the defendant is not voluntarily executing the award and you try to enforce the award in a jurisdiction that prohibits third-party funding, you might have an obstacle here on the grounds of public policy to enforce your award. So you really have to look at all of these elements. The seat of arbitration, is it a seat, is it a country that prohibits or not third-party funding? We have to look at that. Again, as I was saying in introduction, here it's kind of it's interesting because we do have this interplay between, on the one hand, making sure that we have this financial agreement valid and enforceable, and on the other hand, we have to play with the dynamics of a whole different set of rules and laws that apply to the underlying process. So the relevant applicable laws and jurisdictions that we're going to be looking at, what is the law that has been chosen by the parties in the funding agreement itself, the law of the seat of arbitration, as I've just mentioned, and the laws of the likely enforcement jurisdictions. So we have an area, third-party funding, that has really grown exponentially, and yet we are faced with kind of a paradox where regulation is still very scarce. We don't have a lot of regulation at the international level or at the level of each jurisdiction with respect to third-party funding. What we do have is a residual but persistent application in some common law jurisdictions of the common law torts of maintenance and champerty that I mentioned earlier today, which do prohibit third-party funding. And also, individually, in some civil law jurisdictions, you might have some limitations in the Code Civil or in other legislations, which might limit, your third-party funding in the way you would like to design it. Just a very, very recent example in Ireland in 2017, where the Irish Supreme Court literally held that a litigation funder could not fund a case because it was contrary to the law on maintenance and champerty. So as we've seen, we have had an exponential growth of third-party funding, and it initially developed in common law countries, and at the same time we have common law countries that are still vigorously applying the common law torts of maintenance and champerty. Also, if you look at the French Code Civil, you have the concept of retrait litigieux, which does limit the amount that a purchaser can receive if he purchases a legal claim. So you have to really know where you are operating to structure and maximize what you can get out of your funding agreement, and of course making sure before everything else that it's going to be a lawful and enforceable agreement. So we have a lack of clear regulation. Nevertheless, some initiatives have been taken in that field. Some common law countries have relaxed or abolished the torts of champerty and maintenance for arbitration. Hong Kong and Singapore are being very aggressive in that field in really presenting themselves as, modern arbitration seats, and they did modify their legislation this year to clearly incorporate some provisions with respect to third-party funding. We actually had a resolution, the Paris Bar Council, in 21st of February 2017 to give also lawyers more insight as to whether or not it is permitted, and it does confirm that there is nothing to prohibit the recourse to third-party funding in international arbitration, and include some recommendations with respect to ethical duties. I mentioned one example also of, at the multilateral international level, we have some free trade agreements that also now reference clearly third-party funding in their sections on investment, on dispute resolution. Recently, September 21st, 2017, came into force provisionally the Comprehensive Economic and Trade Agreement, CETA, between Canada and the European Union. And it does include a very broad catch-all definition of third-party funders, and it does provide some guidance as it provides an obligation to disclose name and address of the funder. Also, we have, as part of soft law, we have some interesting guidelines as well at the international level. We have the International Bar Association guidelines on conflicts of interest in international arbitration, 2014, that gives some little bit of guidance on these issues of third-party funding. We have the ICC guidance note on conflict disclosures by arbitrators, which is incorporated in the note to parties and arbitral tribunals on the conduct of the arbitration under the ICC rules, published October 30th, 2017, which is useful notes with respect to the ICC process, and it includes, when it comes to the obligation for arbitrators to disclose circumstances that might give doubts as to their independence and impartiality, there are some guidelines. We'll see that a little bit more in detail later. There are some guidance with respect to third-party funders. Again, I'm going back to Singapore, I'm sorry. The SIAC investment arbitration rules, the new rules that came into effect in 2017, that clearly give the tribunal power to order disclosure of the name, of the identity, and where appropriate, more information on the funding agreement itself. And we have a useful code of conduct as well in England of 2014, which is kind of an auto regulation, or it's a voluntary code of conduct for litigation funders that does provide some interesting guidance as well. So now, concluding an effective, once you've done your due diligence and you know that you are going to be concluding a lawful and enforceable funding agreement, let's make sure that it's going to be an effective agreement that is going to work out to every stakeholder's satisfaction. The funding agreement is a bespoke, tailor-made contract structure setting the terms of the investment. Now, it's interesting because it truly is an interface between law and finance, and its negotiation and conclusion for us lawyers will draw from several disciplines, depending on the model used. If it's structured as a debt instrument, as an equity instrument, as a risk avoidance instrument, as an outright transfer, we see that it's pulling and it's drawing from different legal disciplines. And for us lawyers, it's something that we have to get used to when negotiating these kind of contracts. It's not just about the law, but it really is about having in mind important financial considerations and understanding. Another interesting and important peculiarity of funding agreements is that they can involve, and they usually do in practice, involve different stakeholders with potentially diverging interests. You have the funded party, you have the contingency fee lawyer, you have the funder, potential creditors, pre-existing creditors of the funded party, potential insurers as well. So, because of all these stakeholders, an effective funding agreement must ensure interest alignment between all the stakeholders, making sure that everyone has skin in the game. And that's why usually funders like that funded claimant remains involved in the case. They will also require, with respect to the compensation structure of lawyers, that lawyers have skin in the game as well, through a contingency fee or capped fee structure, the funder as well will want to make sure that it has a fair financial return compensating the risk that it's taking. And we're looking at the litigation risk. We don't know if the outcome is going to be successful. And we're also looking at enforcement risk. We don't get any money unless either the award is paid or it's successfully enforced. So we are dealing with high risk for funder. Also, so making sure that we have risk alignment, making sure that we include in the contract necessary mechanisms to resolve, to anticipate and then resolve potential areas of discord. Those include decision over the strategy of the case. Who will decide what do we do? Settlement decisions. What if we have a settlement offer from the opposing party, makes us an offer, the client wants to keep on pursuing the case, and the funder thinks, you know, actually looking at the overall lookout of the case, it's actually a reasonable offer. So if we have, here we can have conflicting positions with respect to claimant, funded, and the funder. So also with respect to termination rights. So for these potential areas of discord, it's important to include in the funding agreement mechanisms that will allow for a resolution of that. Also, an effective funding agreement must provide a fair distribution and a fair order of payment to of the potential proceeds to all the stakeholders. A snapshot, an example of a funding agreement contract structure. Again, it can take many different styles, or depending on the funding model that is being used or the instrument that is being used, it can really take a whole array of different kind of forms. I'm quoting, not quoting, but I'm using this example of a funding agreement arrangement, a contract architecture, where we see here that we're not just dealing with one contract, but very often in practice, the funding arrangement will consist of several contracts. You have the funding agreement itself, you have the lawyer's retainer agreement, priority agreement, that very important document that will set forth the waterfall of distribution between the various stakeholders. You have a standstill agreement that is very important with respect to potential pre-existing creditors, where basically the funder will be asking them to postpone their rank of priority. Security interest, the funder will take a security interest in the proceeds, and potential other kind of insurance policies, such as a default award insurance. So when we see we're dealing with different kind of contracts, you want to make sure that you have coherence, you know, in each contract. We understand that we're part of a bigger structure, so there is coherence between the relevant contractual provisions, and we will also see that in practice those contracts are so important for the funder that very often their conclusion will be made a condition precedent to the signing and conclusion of the funding agreement itself. So I was talking about the importance of providing in the contract some mechanism to resolve potential areas of discord, control over the strategy of the case. We want to make sure, even though the case is being funded, the claimant will retain control over the strategy of the case. Settlement decisions is really an area where we might have some conflict between the claimants that want to continue fighting for the case and funder that might want to accept a reasonable settlement offer. Here we can include some mechanisms such as a veto power, a put option, or also the so-called Q-cell counsel clause, where you have a jointly appointed independent assessor whose decision will be binding on the parties. Of course, you want to, important provision is the cost financed. What are we looking at? Do the costs include costs related to possible enforcement actions, potential liability for adverse costs, security for costs? That's important. Of course, the financial return structure. What is the funder getting? And termination rights are also important considerations. Moving on to the last part, challenges regarding the arbitral process itself. So when we have a third-party funder, we literally have a third party that has a direct economic interest in the case, but that is not a party to the process. It remains a third party. This has an impact on the arbitration process itself, with respect to the risk of potential conflict of interest between the arbitrator and the funder. Other questions with respect to, does it impact in any way issues on cost? How much cost can I get the funding cost back? Can I get the party cost back? Do I need to give security for costs because I'm being funded? These are some of the issues. And finally, some interesting ethical aspects. So the risk of conflict of interest between the arbitrator and the funder. There is a risk, and this is due to different factors. Increase in the number of funded cases, concentrated segment of the funding industry that invest in international arbitration cases. You tend to see the recurring, players in this market. The relationship that exists between funders and law firms dedicated to these high-profile arbitration cases, and of course the system of party appointment of arbitrators. So all of this can create situation of potential conflict of interest situation where you have, for instance, repeated appointments of arbitrator in cases involving the same funder, appointment of arbitrator by a funded party where the arbitrator or the firm has a relationship with the funder in other cases, for instance, that are unconnected with the case at issue. A member of the arbitration sector that is administering the case has a relationship with the funder, and we have different kind of possible scenarios that could give rise to potential conflict of interest issues. The risks are important for the efficiency and integrity of the process. If once the arbitral tribunal is constituted, we find out later on the existence of a potential conflict of interest, that will give rise to potentially having an issue of recusation. Then I have a request for recusation of an arbitrator that will give rise to delay and additional cost. More importantly, if we find out the existence of a conflict of interest after the award has been rendered, and here we are jeopardizing the very integrity of the arbitration award itself by exposing it to potential risks of annulation or inability to enforce the award at the forum for enforcement. So we do have these potential issues. What are the questions raised? This is given rise in order to try to address these concerns to issues of having to disclose when a party is funded, having to disclose that the fact that there is a funding arrangement in place, and having to disclose the identity, who is the funder, to be able to clear from the outset any potential conflict of interest. So what we have these questions as to whether or not we should oblige disclosure, what should be the extent of the disclosure obligation. Here again, it's a nascent, emerging law. We don't have a lot of detailed regulation on the issue, but we do have some pointers, some guidance in what I mentioned earlier, the ICC guidance, note on conflicts disclosures by arbitrator, where basically when it sets forth the obligation for the arbitrator to disclose any facts or circumstances which might give rise to reasonable doubt as to the impartiality and independence of the arbitrator. Here it says that in doing that exercise of disclosure, the arbitrator should also take into account relationships with persons having a direct economic interest in the case. The SIAC, Investment Arbitration Rules, clearly offer a solution as well. It provides that so that the tribunal shall have the power to order disclosure of the existence of a party's third-party funding arrangements and/or the identity and, where appropriate, details about the funder's interest in the outcome, and whether or not the third-party funder has committed to undertake adverse cost liability. And we will see this is directly relevant to the question of security for cost. How has this question of whether or not there should be an obligation to disclose the existence, the identity of the funding, how has that been addressed by arbitral tribunals? There's actually many decisions on the topic and decisions that have involved Latin America. I've used a few as examples. We have the SAS versus Bolivia CPA case, where Bolivia had requested an order of disclosure of both the identity and the funding agreement itself. And in that case, the tribunal agreed to order the disclosure of the identity only, deciding, quote, concerning the second point, the disclosure of the name of the funder, the disclosure of the name of the funder, the tribunal considers that for purposes of transparency, and given the position of the parties, I must accept Bolivia's request disclosure of the name of SAS funder. Concerning the disclosure of the terms of the financing agreement, the tribunal will reject such request. So we understand that for the sake of transparency and protecting the integrity of the process, we do have an interest in knowing who is the funder to clear from the outset any potential request. Another example is the Jovelec versus Bolivia CPA UNCITRAL case. Again, where the tribunal did order the disclosure of the identity, and as mentioned in paragraph 9 of the award, in order to remove any doubt, the members of the tribunal hereby declare that they have no relationship with Salvi Investments Limited and are not aware of any circumstance that could give rise to justifiable doubts to their impartiality and independence on account of the financing of the claimant's claim. So moving on from this question of conflict of interest, potential conflict of interest between arbitrators and funders, and what do we do to deal with it? Do we impose an obligation of disclosure? If we do so, to what extent? Moving on to another interesting issue in practice that has to do with cost. And the question here really is to know whether the existence of the funding arrangement has any impact on the issues regarding cost. I mean, as we know, for instance, at the end of the process, the arbitral tribunal will render a cost award in which it will decide the amount of cost that can be recovered and what will be the allocation of cost between the parties. When we have third-party funding, here the concern with respect to security for cost is exposing the non-funded successful party to what has been called as a hit-and-run arbitration, where basically the funded party lost the case, and we know that because it has been funded, it is likely that it might not be able to comply with financial obligations under the award. And another issue is that, as we know, the third-party funder, even though it has a direct economic interest in the game, in the claim, he's not a party to a formal party to the arbitral process, and therefore the arbitral tribunal does not have jurisdiction over the third-party funder. So this is the situation that we have. What has been the party's response in practice when they become aware that the opposing party is being funded? What they do is to request a security for cost to tribunals. How has this been addressed in practice? Traditionally, the position of arbitral tribunals has been to require a proof of necessity of the measure of the security for cost, as well as urgency, in order to order security for cost. So here, in the context of third-party funding, the question that has arisen is whether the very existence of a funding arrangement is sufficient to justify an order of security for cost. The trend that we have seen in practice with respect to the awards that have been rendered by tribunals in this area has been to indicate a refusal to order security for cost on the sole ground of the existence of a funding arrangement, save in exceptional circumstances. For instance, in the case that I was mentioning earlier today, SAS versus Bolivia, Bolivia was asking not only for disclosure of identity and details of the funding arrangement itself, but also for security for cost. And here, clearly decided by the tribunal, it stresses the fact that the element alone, the existence of a third-party funder, this element alone may not lead to the adoption of the measure. The existence of a third-party funder alone does not evidence the impossibility of payment or insolvency. It is possible to obtain financing for other reasons. The fact of having financing alone does not imply risk of non-payment. And as we have seen earlier today, it is true. The area of third-party funding has evolved tremendously to offer now products that are not, a party will not necessarily seek funding because they can't afford to pursue the claim, but because they want to use risk management mechanism to share the risk with another party. So, in paragraph 78, in sum, the existence of a funder is an element to take into account, but tribunals have been clear in that the existence of the funder alone is not sufficient to grant security for cost. This position has been reiterated in many other awards. Another example is the Belmont case versus Slovak Republic, where the tribunal mentioned the tribunal is of the view that financial difficulties and third-party funding, which has become a common practice, do not necessarily constitute per se exceptional circumstances justifying that the respondent be granted an order of security for cost. So as we've seen, the requirements are to establish some exceptional circumstances, and here we have a tribunal that tells us that the existence of the third-party funding arrangement itself will not constitute exceptional circumstances. An example of a decision where the tribunal did find sufficient exceptional circumstances to justify ordering security for cost was in the case of RSM versus St. Lucia mixed case in procedural order of August 13th, 2014. Here, RSM had requested security for cost. It had requested an irrevocable bank guarantee of $750,000 as security for cost to cover the expected legal cost in the claim, in the arbitration. And in that case, the tribunal was satisfied with the existence of exceptional circumstances and did order security for cost. And he found a set of circumstances which cumulatively, in its view, amounted to urgency and exceptional circumstances in that matter. And these elements were a proven history of claimants' failure to comply with cost orders and awards due to its either inability or unwillingness in other exit arbitration cases. So respondent had been looking at what had been the procedural conduct of claimants in that regard, in the context of complying with orders to pay, and it had been established that it had not been a very compliant candidate. Also, there was this in combination with the fact that it had been admitted that there was financial difficulties in that particular case to fund the case, and also the funder was an unknown party. So all of these aspects taken cumulatively were deemed sufficient to justify ordering security for cost. So that was some issues with respect to security for cost. Now moving on quickly to costs themselves. What impact, if at all, does third-party funding have on the award and allocation of costs between the parties? Some interesting documents that we can look at is the recent Queen Mary University of London task force on third-party funding in international arbitration, the subcommittee on security for cost. It was a draft report of 2015, and also there's the ICC Commission report, decision on cost in international arbitration, and also we can take a look at some arbitration awards that do offer guidance in this area. So some of the questions that we are looking at, if I'm a claimant that has been funded in order to pay my legal costs, my legal fees, attorney's fees, arbitration costs, does that mean that as part of the arbitration award I will not be able to recover them because they were funded? And the position that has been unanimously adopted is that this has nothing to do with it, because if I had not been funded, I would be able to get them back. So the existence of the funding agreement should not place claimant at a disadvantage in that regard. And I just mentioned a couple of exit cases here, but it has been affirmed in many cases. Allocation of cost. Does the existence of a funding agreement, should it impact in any way? For instance, when we know that we are in a context where cost follow the event principle will apply, outcome-based methods of cost allocation, we know that they will apply. Should the existence of third-party funding impact at all the application of this cost follow the event principle? Here again, no, it should not be a relevant factor. I've seen some differing position with respect to the question of the funding cost. So I'm not talking about the legal costs and the attorney's fees that have been funded, but about the actual fee that you'll have to pay to the funder in case your case is successful. There was the question as to whether or not you might be able to also, as part of the award of costs, recover that. The position in the ICA Primary Task Force was to say that it's not appropriate for tribunals to award funding costs as they are not procedural costs incurred for the purpose of an arbitration. However, they did mention the possibility for these funding costs to be recovered as damages under the applicable governing law. The ICC Commission in its report specified that in certain circumstances, funding costs may be recoverable if they were incurred, and they were indeed incurred for the arbitration, paid or payable, and if it's a reasonable amount. Another question is whether the tribunal can order the third-party funder to pay costs. So here we are in a situation where a funder funded a claim, but they lost. So the other party, which is not funded, is successful. The question is, as part of the award on cost, can the tribunal order the third party to pay those costs to the successful party, non-funded party? Here, the point is that, as we said earlier, the arbitral tribunal doesn't have jurisdiction on the third party funder, so that technically the answer is no. With respect to funding of costs, being able to recover those costs, I just wanted to mention a recent decision in England, which was actually an ICC case, an ICC award, with a seat in London that was governed by the ICC rules because it was seated in London by the English Arbitration Act of 1996. It was an interesting case because in that case, the tribunal, which was actually a sole arbitrator, as part of the award of costs, awarded to the successful funded claimant also the funding fee that he would have to pay to the funder. So the funding was about £650,000 in return for the highest of 300% of the funding, so 3 times the funding, or 35% of the recovery. And in that case, the sole arbitrator had ordered the defeated respondent to actually pay this as part of the award on cost. There had been a challenge before the English High Court, because the seat was in England, to challenge this on the ground that the arbitral tribunal did not have jurisdiction or incurred and engaged into an excess of power by ordering this, relying on relevant provisions of the English Arbitration Act, but the challenge was denied and the award was upheld. It is interesting to note that there have been some specific circumstances in this case where in the award the arbitrator did mention the critical conduct of the other party in terms of bad faith at the time of executing the contract and thereafter in the conduct of the arbitral process itself. So these considerations definitely did come into play. Finally, some last considerations of an ethical nature and evidentiary nature, some questions that do arise as a result of third-party funding. I mean, as we know, and that was the purpose actually of the resolution of the Paris Bar Council on the 21st of February of this year, to give more clarity or guidance to the lawyers with respect to third-party funders, is to remind lawyers that to not get confused. I mean, we traditionally have a binary relationship, attorney-client. Here we're dealing with a third guest. it's important to not forget that your ethical duties as lawyers are due exclusively and solely to the funding party. And it's important because at some point in the implementation of the course of the process itself, in the course of implementing the funding arrangements, there might be situations where there will be conflict of interest between the parties in terms of settlements, discussions, and negotiations. Let's not forget that you are representing your clients. Very interesting questions of confidentiality and legal privilege as well. Here, the key objective when it comes to maneuvering all this third-party funding arrangement situation is to make sure to not waive any kind of legal privilege and legal secrecy that protects the exchange of communication between the attorney and the client, because here you're going to be communicating confidential, privileged information to a third party. So you want to make sure that by doing so, you're not going to be waiving very important privilege in the process, because if you are waiving them, they can be subject to disclosure from requests for production by the other party. This is a very complex area of law that we could dedicate hours to speak about, but I just wanted to raise this. You have many laws to look at when addressing these issues. You know, what law will regulate issues of legal privilege? You have many contenders. The law of the seat, of course, the ethical duties of each party. Substantive, there was a debate as to whether legal privilege is a procedural question, procedural rights or substantive rights. Some countries consider that it's a substantive issue. So we have conflict of law, very complex conflict of law analysis. I will just mention the interesting guidance that we can get from the IBA Rules on the Taking of Evidence of 2010 in Article 9. They do give you some interesting guidelines on this. Also, last question, I mean, the funder, in doing its own case due diligence, will be engaging his own lawyers or will be doing work on his own to try to assess the merits of the case. What is the status of these documents? You know, we do have a lot of very interesting questions and a nascent regime in that area, so there is a lot to do in that field. Loyalty and conflict of interest, again, you know, there might be some diverging interest between all the stakeholders at some point. Remember that you have to be loyal to your client. There are some concerns that have been raised in practice. What about funders that do access very sensitive, confidential information when funding a case? The possibility for them to use that information in another unconnected matter that may conflict with the interest of the original client. We have a lot of very interesting questions that do arise in that field. In the US, for instance, also, lawyers cannot split fees with non-lawyers. So we have specific ethical considerations. So when you structure the payment, you make sure that you structure the payment so that you're not placed in a situation where you're sharing fees with non-lawyers. So this brings us to the end of this presentation. Thank you so much for your attention. And any questions that you might have, I'm very well happy to address them. Thank you. Yes, Carolina. I knew I would have some questions from you.
Gracias, Aurelia. Definitivamente esta es una gran posibilidad para que se viabilicen arbitrajes que de otra forma no podrían llevarse a cabo. Lo hemos visto en otras partes del mundo. ¿Cómo ves tú, desde tu experiencia y desde tu investigación, esta posibilidad para la región latinoamericana y específicamente nuestros países centroamericanos? ¿Lo ves como algo muy lejano o lo ves como algo cercano?
Thank you for your question, Carolina. As I was saying, it's interesting, and I chose to speak about this because when you look at investment arbitration decisions that have been rendered in the field, many involve Latin American countries, South American countries, Central American countries. So it is existing, definitely. Of course, with respect to commercial arbitration, we don't have access to that information except when there might be some issue with respect to the implementation of the agreement, funding agreement itself, where actually you have to be able to access some information when you have, for instance, a dispute before U.S. courts, and then you can have access to more detail about the funding arrangements. But definitely, it is expanding globally. There is a market. I mean, there's a lot of investment arbitration involving Latin America, so definitely there is a market for it in this region. There is a market for third-party funding. As I've said, some seats are being very aggressive. We have the example of Singapore and Hong Kong that have been very aggressive in revising their legislation to clearly provide for the possibility of third-party funding in international arbitration. We have the SIAC investment arbitration rules that give some guidelines as what do we do when we have this. So there is a market. What can be done is to provide more clarity. One issue when we don't have clarity as funded, parties that are seeking funding or parties that are involved in a case that has a funding arrangement in place, we need previsibility with respect to our potential exposure for cost. If I'm a defendant in a case and I might have to pay as part of the award of cost, the funding cost of the party, all of these are risks, and there is definitely a lack of clarity in the context of cost and in other contexts as well. So what can be done is to participate in this kind of global movement to give more clarity, to modify when it's necessary, or to add specific provisions in legislation to give clarity, to reassure the parties that this can be done. In common law countries, we have the obstacles of champerty and maintenance, which were common law torts that did represent some obstacles to the growth of third-party funding at some point. We've seen recently in Ireland in 2017. In civil law litigation, we don't have these common law torts, so we don't have the same obstacles. And here in Latin America, we're civil-based countries, unless we have isolated little provisions that could have an impact on how you structure your deal, a priori, we don't have obstacles to these kind of mechanisms being used here in Latin America. But definitely more clarity is desired. Yes?
Thank you, first of all, for everything that you have shared. It's so useful. For me, it's a relatively new subject area, and my question is more in terms of cost. Has this new figure of third-party funding affected the cost of arbitration? I mean, it's already expensive, so.
Well, it does not. The only thing that it's going to do is it's going to split the proceeds between whoever is taking part in the funding arrangement. In terms of the arbitration cost themselves, it's not having an impact. The point is precisely to get some help, outside help, to be able to face the cost. Again, it's the claimant that will see a reduction in whatever proceeds it might have, because the share of it will be reduced depending on the arrangement with the funder, but it has no impact on the actual cost, which independently exist, and they're based on amount in claim, about whatever fees the attorneys are billing, and it really is independent. It's designed to help that problem of cost in international arbitration. Well, if there's no other questions, thank you again very much for your presence here this morning.
Muchas gracias a ustedes por esta excelente presentación. Es un tema novedoso que definitivamente genera mucho interés, muchas preguntas, muchas consultas, pero es importante estar al día y avanzados y empezar a investigar este tipo de cuestiones que sin duda realizarán arbitrajes que de otra manera no podrían llevarse a cabo. Así que un agradecimiento enorme a Aurel, que además, como ya les comentaba al inicio de esta presentación, se acaba de incorporar a nuestra junta directiva. Así que estamos muy contentos de tenerte entre sí y muchas gracias por tu presentación. A ustedes gracias por acompañarnos una vez más y los invitamos a que continúen siempre viendo las actividades que nosotros tenemos acá en